All right, well, welcome back, everyone. We hope you had a pleasant break, and we continue to offer you very thought-provoking training for the Elder Justice Training for 2021. It is my great pleasure to introduce our next speaker, Scott Mertz from Legal Aid of Nebraska, and he'll be talking about housing and tenant issues. Scott is the managing attorney of Legal Aid of Nebraska's Omaha office and director of the firm's Housing Justice Project. A 2009 graduate of Creighton School of Law, go Blue Jays, Scott has worked at Legal Aid of Nebraska since graduation. The Housing Justice Project encompasses all housing work done at Legal Aid of Nebraska, and the project seeks to ensure that all low-income Nebraskans have access to an attorney for their housing legal issues. So please join me in welcoming Scott Mertz. Scott, thank you, sir.
Thank you. Thank you very much. So today I will be discussing landlord-tenant law in the state of Nebraska. Specifically, I want to go over the updates to our laws here in 2021, and with providing those updates, get into some of the broader context of eviction laws and how evictions work in the state of Nebraska currently, so that people have a basic understanding of their rights as tenants and the responsibilities and obligations of a landlord who seeks to remove any tenant from the rented property. A lot of changes came to Nebraska's landlord-tenant law at the end of the legislative session via LB 320. This was an omnibus bill that passed the legislature on April 29th of 2021. It incorporates not just one, but many revisions to the Residential Landlord and Tenant Act, all of which are now effective as of August 28th of 2021. So we're just a couple months into these laws making their way through the courts and through the practices of landlord attorneys. And I'll go one by one through every one of these changes, but I'll also kind of address kind of how all of these pieces, all these changes fit into the larger context of landlord-tenant laws in the state of Nebraska. First, I want to start with right of access. This was a seemingly minor but quite substantive change to tenants' rights. It deals with the right of access from a landlord accessing the property that is occupied and being used by a current tenant. Fundamentally, it's what is substantive about right of access is not changed. A tenant may not, quote, unreasonably withhold consent. Similarly, a landlord may enter a dwelling unit without consent only in the case of emergency. So there's always a requirement for consent. Tenants can unreasonably withhold it, and landlords can only access without that consent if there's an emergency. That remains the case, and that's been the case. What's changed is adding a lot of specificity and direction as to how the request for access, how the request for that consent shall be made by the landlord. It's now specific that the request for entry must be at least 24 hours in advance. Law used to say a day. There's a bit of confusion, some wiggle room with some landlords there, notifying someone the night before they want to come in the next morning. Now it's clear that request must be at least 24 hours in advance. The request must be memorialized in writing, and that written notice must articulate the purpose for the entry. You can't just say, I want to come in. You've got to indicate what it is. There's got to be a reasonable basis for that request for entry. And the period of entry must be during a reasonable period during which the landlord anticipates making that entry. You say when to come in whenever. Can't just say it's going to be dead of night, early hours, inconvenient times. There's an expectation that request must be reasonable. And the written notice must go out to every single unit. Can't just post a written notice in the hallway to cover, all the units on floor 3. You're a tenant, the household is in any unit in a multifamily dwelling. If the landlord wants access, it's anticipating repairs, showing the unit for potential new renters, treating the place for some kind of pest control needs, that's fine, but you got to follow these steps. Written notice, specifically articulated, at least 24 hours, and everybody gets a copy. Do that, landlord's in violation of the law, may be liable for some damages. If the landlord is following this process and there's an unreasonable withholding of consent from the tenant, risk of the tenant being in breach of the lease agreement, potential for early termination of that lease agreement. Okay, changes to our restitution complaints. This is where it all starts in a court proceeding whenever a landlord wants to evict a tenant. They start with the filing. That initial filing is called the complaint. And there are certain requirements as to what must be in that complaint if a landlord is seeking a restitution that is an eviction from a county court. As has always been required, landlord must state the facts of the case with some particularity, what's going on, why it is the landlord is seeking the eviction. There must be a reasonable, accurate description of the premises. And quite importantly, the landlord must state in the complaint that they have required with the requisite notice requirements. Whatever the reason for the termination, one's going to court as a landlord. Before they got to court, they must have given a written notice to the tenant, indicating that perhaps they're behind on the rent, very common reason for a termination, that they had done the requisite notice in that case, a 7-day notice for non-payment of rent. Could be some other violation, could be a criminal allegation, in which case they must give a 5-day notice without any opportunity to cure to the tenant. Whatever the notice was, it's got to be in the complaint that you complied with your notice requirement. What's new? What's new is not just the statement of facts and that notice compliance, but you also have to state the statutory authority. The legislature now wants in complaints citations to the actual law of which the landlord is seeking the relief, the possession of the unit, the eviction. This is going to aid not just the tenants and their representatives in understanding the legal theory behind the eviction, thus enabling them to better prepare a defense, to really know what legal theories are in play in the case. It's going to aid our Nebraska Supreme Court, who going forward in 2022, every year, twice a year, are going to issue a report to our state legislature on eviction filings in the state of Nebraska, where they're happening, how many are happening, who's got representatives, how many default orders were entered, and now with this requirement, what kind of evictions they were. If it was non-payment evictions, because the statutory basis will be in there, we'll more easily know how many non-payment evictions there were. If it was a criminal act violation, they'll have to cite that legal authority, much more easier for the reporting of the Supreme Court, indicate how many cases were due to a criminal action on the premises. Okay, changes to the method of service in an eviction case. So when you're a landlord and you're starting your eviction case in court, and you file that complaint and you've done that properly, what's the next step? Next step is service. You're filing a case, and you have to make sure that complaint gets to the defendant, that is your tenant, with the requisite summons issued by the court, indicating that those individuals have been sued in their rights as a defendant in the case. So mostly, again, unchanged substantively, as has always been required. There's got to be service. That service must be within 3 judicial days, 3 business days, however you want to call it, that this must occur after the filing of the case, after the issuance of the summons from the court. That's when the clock starts for those 3 judicial days. Primarily, you'd attempt to do it via personal service, just like the typical way people consider service, that there's a process server, a constable, a sheriff, finds the individual, complaint, summons in hand, they give it to that individual, and they notify the court. That is the typical means of service in any civil action, and that's still the case in an eviction action. But if it's an eviction action, and if you can't personally serve somebody, after quote-unquote diligent efforts, that is, after you have attempted to actually try to perfect service via those means, you are allowed by statute to do constructive service in an eviction case. And so what that means, if you can't do that personal service after you've tried within the 3 judicial days, you can do it by posting the summons on the dwelling unit, on the front door of that unit, and then you file with the court an affidavit, and that's really what's changed here, the contents of that affidavit, that the process server must notify in the affidavit the court how diligent efforts were made. Did you really try? Were there really diligent efforts? What were they? And that they failed, that you not only left the summons at the address, but as I stated, posted it on the front door of the dwelling unit. That's new language, a new phrasing there, to indicate that it wasn't just left at that address, but actually at a spot where most likely the tenant would see that summons more readily, more easily, such that they are not finding out about the eviction after the fact and or seeing it too late in the process. Again, these changes were made to really strengthen the odds that the tenant is going to know about the eviction case on time. Legislature was saying that too many people were not showing up to their eviction hearings. Why was that? If the service was happening, did people just think they had no rights, or were they just not knowing about their hearings? Whatever the case, the changes still allow for the basic means of service, that constructive service option still being available to the landlords, but there are extra requirements for what must be filed in the affidavit with the court to indicate that these the rules have been followed and that constructive service or personal service have been followed correctly. Continuances. So this gets to the trial, the hearing, when you're in front of the judge. After you've been sued, after you've been served, you're in front of the judge. Before you proceed to an actual trial on the eviction, can you get a continuance, if necessary? So this is a major change. Before, you can only get a continuance in an eviction case for extraordinary cause. Specific language put in to Nebraska's Landlord and Tenant Act to indicate that it must be some extreme need to get that eviction hearing continued beyond what's normally required in other civil actions. Good cause, that you have some manner of just good cause that you need the continuance before a judge would rule on your request for a continuance. And furthermore, you would have to show extraordinary cause. You also have to pay into court any rent due between the time of that requested continuance and before you're in front of the judge again. So that's been amended. It's not fully repealed, but rather now in the statute, you can get your first continuance, either party, landlord or tenant, and get their first continuance for just that good cause, just like anybody else in any other civil action in Nebraska can get a continuance for merely showing good cause. That's true for that first bite at the apple from either party, and you don't have to pay anything in to court if you're getting that first good cause eviction. And the law says after you've gotten that first request, if there's going to be any other continuance, then it's got to be extraordinary cause, and then you might have to pay into court just like before. So there's greater opportunity here for individuals who are in any way unable to appear because of conflicts, medical needs, just whatever is a barrier or an impediment to you actively being present, actively trying your case, that you have a little more of an opportunity to have a fair day in court, even if it's at a later date and time. Okay, a major substantive change to the Landlord and Tenant Act in Nebraska, the creation of this statute at 1431.01, where there was no such statute before. This creates a right, a new right for tenants if one is a victim of domestic violence or a household member of a victim of domestic violence. Here, if either of those things are true, you have means by which you can be released from your lease agreement. Now, this is important because if you're an individual who is a victim of domestic violence, likely you are residing with the perpetrator of that domestic violence, and because of a protection order, because of a criminal action, because of just a need for health and safety for you and or your family, you need to get out of that residence. But you got a rental agreement. Rental agreement says you're on the hook for that lease agreement for a period of maybe 12 months. You're on the hook for a lot of rent still if you break that lease agreement early. You're on the hook for perhaps early termination fee. Now individuals who can document that they are victims of domestic violence, that they qualify for the protections of this statute, can document how they qualify and provide written notice to their landlord as long as it's at least 14 days out from the date that you're asking to be let off the lease, and no more than 30 days out. So it's a window of 14 to 30 days by which you're requesting to be released from the, or not requested, but informing your landlord that you shall be released from the lease agreement. If you follow the steps, if you properly qualify as a member of this protected class, you can be protected from liability for anything on that lease agreement outside of that time frame. This is something that existed for individuals who are in federal properties, public housing, low income tax credit properties, etc. There were federal laws that protected individuals of domestic violence and allowed them to get out of lease agreements and otherwise be protected from evictions as a victim of domestic violence. But now the statute is statewide, so no matter what kind of property you live in, you get this protection if for any reason you qualify as a victim of domestic violence. And similar and built upon to that statute, there's changes to 1431 proper that deal with non-compliance notices. These are where you find the notices for termination of the lease agreements, terminations for non-payment of rent, criminal activity, for other breaches of the lease agreement materially affecting health and safety. This is where you go in the statutes to find how you would do the proper notice. And here, amendments have been made so that if you are a victim of domestic violence, you would not receive a notice for early termination, for an eviction notice. If you're perhaps an individual who has a domestic violence, wants to stay in the unit, as opposed to the individuals who want to be released from that lease agreement, but have in turn actually removed the individual who perpetrated the violent act. They're gone, you want to stay, but perhaps you have a situation where the criminal action occurred on the property. Landlord might send a 5-day notice to that household because, hey, the police officers came by, or an arrest was made, what have you. That came to the attention of the landlord. Usually if there's a criminal action that's violent and or involving drugs or otherwise materially affecting health and safety, landlords can just do a straight 5-day notice to quit to the household. But we have the exception here now for victims of domestic violence. If you are the victim of domestic violence, you shall not be held to a 5-day notice to quit. That wouldn't make sense, obviously. But for just making sure it's specific, to make it clear in the statute that the perpetrator of the violent act and the victim of the violent act should not be subject to that same 5-day notice. You get protections if you either sought a protective order, cooperated with law enforcement, or, and again, this is new, you got third-party certification from the proper qualified organization who work with victims of domestic violence, who can just document that this person, certify, corroborate that this person is a victim of domestic violence. For those individuals who don't want to seek out a protective order or otherwise go through law enforcement to address the domestic violence, they still have that opportunity to qualify for this protection through that third-party certification. Okay, so another bit of a catch-all of various changes to the laws. There was a harmonizing between differences in the mobile home landlord and tenant laws and the residential landlord and tenant laws. So just by the very nature of me identifying the need for these harmonization, that means there are different laws, a different statute covering those who rent a trailer park lot space on a mobile home park and those who rent a residential dwelling. Reason for this is there's going to be different obligations of a landlord if all they're renting is a plot of land with utility plugins and otherwise just the basic amenities in a trailer park, as opposed to those who own and rent out a multifamily dwelling unit, a single-family dwelling unit, a fixed residential property. Furthermore, there's a lot of different nuances to those laws because of the complications when you have a renter of a lot space who is the owner of the mobile home, as they are the owner and the caretaker of their actual fully owned dwelling, even if you're renting the land, the lot space in the mobile home park. It makes for a lot of complications and a lot of problems for the renters in those mobile home parks. Problems such as what we had in the last 2 years, where there were differences as to certain obligations of the landlords in those trailer parks and the landlords in the residential units. Because in 2019, the last time we had any serious changes to the landlord and tenant laws of Nebraska, those changes were memorialized in the residential aspect of landlord and tenant law, but not the mobile home statutes for landlord and tenant law. Primarily, this is with the notice requirements and with security deposits. So you had a situation there for a couple of years where if you were behind on rent and you were in a residential property, you were entitled to get a 7-day notice, a written 7-day notice to indicate how much you were behind and that you had those 7 days to cure pay up that money owed. Otherwise, the landlord would go forward with an eviction action. But if you were in a mobile home, the law said you only had to have 5 days written notice, 5 days to be current on your rent money. And again, prior to 2019, it was a distinction that actually favored the mobile home tenants, because prior to 2019, it was just a 3-day requirement. We had only 3 days for many decades here in Nebraska. If you were behind on rent, you were only entitled to get written notice that you just had 3 days to get caught up. Again, no time at all, something of an absurdity. That notice would go in the mail, you would maybe see it perhaps as late as the 3rd day to know, I gotta get caught up on my rent money, otherwise I'm without the right to cure, and I may be sued without that opportunity to get caught up on the rent money. Whereas in that case, the mobile home tenants had the 5 days and thus a couple extra days, but then the discrepancy was, again, repeated, this time favoring the residential tenants in 2019, but no more. Now everybody's got 7 days, no matter where you rent. If you're behind on your rent money, you have a right to get a 7-day written notice. So that's the harmonization there to resolve that discrepancy. Other discrepancy, security deposit law, again, 2019, fixes were made to our security deposit laws as a aspect of residential landlord and tenant law. Prior to 2019, it was on the tenant. The obligation was the tenant's to recover your security deposit. You move out of a unit into your tenancy, you want your security deposit back, that's on you. That was on you. You had to put in a written demand and do it within 14 days to get your security deposit back, and then the landlord had an obligation to either return it to you or provide itemized documentation as to how that deposit was used. 2019, no more obligation goes to, or the responsibility goes to the landlord. You're a tenant, you leave, it is on the landlord to return the deposit to you within 14 days, or get to you as a tenant a written itemization as to how that deposit was used. Purpose of a deposit is to go towards any balance owed, either because of unpaid rent or because of damages to the property. So law recognizes, great, you've got 14 days to figure out how and if you want to apply that security deposit to any rent owed or damages to the property. But within 14 days, either return the money or get that written itemization out. And that is now a requirement for both those in the mobile homes and in the residential properties. No matter where you are a tenant, it is the landlord's responsibility, not yours, to return the security deposit or otherwise document how the security deposit was used. So, harmonization of rights to favor the tenants now between mobile homes and the residential tenants. So those are the changes effective as of end of August 2021. Again, this is simply, I believe I can say, the most that the landlord and tenant law has really been changed in one legislative session since our adoption of the Nebraska Uniform Residential Landlord and Tenant Act. And again, all of them, as you can see, strengthening tenants' rights. So with minimal time, if we have other questions?
Any questions?
Okay, thank you. Okay, the question is, who do we turn landlords into for entering homes without notice? So the answer to that question is going to be uniform to any time you have a landlord who is breaching some aspect of landlord-tenant law. Now, there are specific remedies and opportunity for early lease termination that attach to that right of access statute, but who do you turn to? You're really going to want to consult with an attorney before doing anything to make sure you're in the right and you're properly following landlord-tenant law, but always consult with an attorney, particularly if you want to go outside the scope of the lease agreement. For example, terminate early because of a violation like this, the violation of the right of access. You may be entitled to statutory damages as well, but again, that would depend on the circumstances behind any violation of any aspect of the Landlord and Tenant Act. But do be aware of, just what your rights are as a tenant. Again, you're entitled to something, but at the same time, the landlord is also entitled to something that is right of access so long as it is reasonable and they have complied with the notice requirement to the tenant. I think like with all aspects of a potential landlord violation of the statute, you want to make sure you've got some manner of a record, documentation. We always say it's a notice pleading state, and everything in the Landlord-Tenant Act comes down to notice, and it's always good to have formal written notice of anything. In a situation like this, perhaps just to notify a landlord of your objection to any entry that is in violation of the right of access statute, maybe because there was no emergency, or because the request itself was not reasonable, or the hours of entry were not reasonable, whatever that may be. It's always best practice, your communication, your stated objection to whatever is happening or not happening in your property is in writing, dated, signed by you, and you retain a copy of it for any potential need to verify a timeline and to verify that proper notice was given to the other party. Okay. Were there any other questions? Okay. Well, I would just, okay. Again, I just want to be clear. I've outlined a number of rights for tenants, and there are many more. And individuals don't necessarily know what rights they have until they have consulted with an attorney. And so, if anybody receives a notice for termination, even before they get sued by a landlord in eviction court, consult with an attorney. Those written notices are serious. That's the step one of a process that may end up with you in court and may end up with you being evicted. So it's always good to get the facts straight in your rights or your obligations straight with a lawyer. And if you cannot afford a lawyer, that's what Legal Aid Nebraska is for. And Legal Aid Nebraska is, of course, a statewide organization for any of those who are low-income renters and are otherwise scared, confused, seeking clarity and seeking some understanding of anything that they receive from a landlord. I would also note that we're about 20 months into a serious pandemic here in Nebraska, and during that time we did have, as housing advocates and our low-income tenants did have some federal protections that are no more in terms of the moratoriums. But that doesn't mean that all protections are gone. We still have defenses, as I've touched upon, but there's always an opportunity to present a defense whenever you have a day in court, and that's why it's necessary to consult with a lawyer before going to court, and why it's important that people have access to lawyers before they're evicted. And even though those moratoriums are gone, I do want to highlight the fact that here in Nebraska and really all across the country, there is still rental assistance available for low-income renters. And so if anybody is scared because they are behind on rent or have received notices of non-payment of rent, depending on where you live, there are entry points, portals for accessing and applying for rental assistance. That money is still available if you qualify for and are behind on your rent money. And it won't be around indefinitely, but it is still here right now. So it is important that people understand that that's an option for them if they need it. And that's just not for the tenants as well, that's for the landlords as well. If you're a landlord and you have tenants behind on rent, you also are eligible to start the application process and perhaps access that relief money. So just understand, depending on where you live, you've got different places you need to go online. Legal Aid Nebraska's website has those. The state's website has those links as well. Don't be afraid to ask questions and just investigate what you might be eligible for before it's gone.
Excellent. Thank you so much. Thank you.
Thank you.
Very good. Thank you.